everyone. Welcome to Crime in Court. This is episode 100 of the Canton cover up series, Commonwealth versus Karen Reed. We also talk about Aiden Turtleboy Carney, but not today. We're just going to be talking about Karen Reed because in this case, in Karen Reed's case, the defense has filed some new motions and there are some bombshell revelations. And you'll see the Sally Port and Brian Higgins are on the cover of this thumbnail, and you'll see why as we begin reading. Although, to be honest, I haven't read through the whole thing. I've only seen like kind of bits and pieces from what other people have said is in there. So um, I'm reading it, in real time with you. But before we do that, I had a couple housekeeping items that I wanted to get to. But before I even do that, can you please hit that like button? Because it really does help the algorithm. And for some reason, I think that YouTube has long ago shadow banned my video because it doesn't get out to a lot of non subscribers. So any little bit helps. Anyhow, thank you so much. Thank you for being here. That helps too. All right. So the first thing I wanted to bring to your attention was I'm going to try to be diligent about giving you guys links to the court documents when we go over specific court documents in our videos. So this first one is the link. This is where you will be directed from the link that is down below in the description of this video. So you'll be able to find three documents that we're going to go over today. So we'll get to that in a minute. But up first, I wanted to read to you the Department of Justice's announcement here. All right, so Leah Belair Foley will serve as the United States Attorney for the District of Massachusetts. So if you recall, Josh Levy just retired. He was just basically, he was the interim until they made him the permanent. And then just shortly after he was the permanent, then he retired. So I wonder where he's going. He probably has some plans. But anyways, all right. So as Assistant U.S. Attorney Leah Belair Foley was appointed as the United States Attorney for the District of Massachusetts by Acting Attorney General James McHenry. He was Attorney General for like a day, and then he turned around and was like, "I don't want it. My first job as the Acting General is giving giving someone else a job." So on January 20th, 2025 is when that occurred, that he handed the reins over. With more than 2 decades of experience as a federal prosecutor within the Department of Justice, Ms. Foley brings extensive experience in prosecuting complex federal crimes and leading significant department operations. So I know specifically that Levy had, his specialty was corruption. So I'm hoping that Leah, Ms. Foley, is going to continue on that same path. Although just saying complex federal crimes and leading significant department operations is not very specific. So I wonder if she has anything in her background that would specifically align her with dealing with corruption and corrupt DAs and law enforcement and things like that. So, Ms. Foley was sworn in this afternoon. When was this? January 21st. She was sworn in on January 21st by the U.S. District Court Judge Nathaniel M. Gorton. And then she has a quote here. She says, "I can think of no greater mission than that of public service, and it is an honor of a lifetime to now serve in the capacity of U.S. Attorney. I am profoundly humbled by the opportunity to serve our great nation as the Chief Federal Law Enforcement Officer in Massachusetts. I look forward to working with the outstanding men and women of the U.S. Attorney's Office and our local, state, and federal law enforcement partners to protect our communities and support the principles of the rule of law." support the principles of the rule of law. I feel like the rule of law has gone out the window in certain areas of Massachusetts, especially the Norfolk County. So let's see what she brings to the table, shall we? I hope if anybody has like more information on her or wants me to go, I'd be happy to do a little more research on her and see, or if somebody has info on her, I can report back that, if she has some kind of background in corruption, that would be really a good thing to know about. So Ms. Foley has been a federal prosecutor for 23 years, first serving as an assistant U.S. attorney for the District of Columbia. Oh, so she was in D.C. as an attorney? Assistant U.S. attorney, sorry. And most recently, the District of Massachusetts after joining the office in 2006 as an assistant United States attorney in the criminal division. Prior to being appointed as U.S. Attorney, Ms. Foley served as the Deputy Chief of the Narcotics and Money Laundering Unit, where she supervised international and domestic narcotics investigations and international money laundering, immigration, yeah, that human movement. I don't think I can say that word, moving of human bodies, and firearm cases. So, no corruption. That's unfortunate. She also served as the lead attorney for Boston's Organized Crime and Drug Enforcement Task Force. Isn't trying to think. I thought Brian Albert was more in like the crime, organized crime, drug and gang type law enforcement. So I don't know. She might have a similar background as him. As an assistant United States attorney in the District of Columbia, Ms. Foley prosecuted violent crimes, sex crimes, felony narcotics, and firearms cases. She also authored appellate briefs and argued before the District of Columbia Court of Appeals. I don't know if she's the right fit for right now, to be quite honest. I don't know if she's the right one for dealing with the mass corruption in Massachusetts, if I'm going to be fair. But if anybody has another opinion and knows about her, I am not from the area, so anyone who has more info and can say, yeah, she's going to be tough on them or not, let me know. Let the rest of us know. All right, so prior to her tenure with the Department of Justice, Ms. Foley served as counsel to the United States Senate Committee on the Judiciary from 98 to 2002, where she advised Senator Orrin G. Hatch, chairman of the Judiciary Committee on Drug Policy and other criminal law matters, negotiated policy issues with representatives of elected officials, federal agencies, public interest groups, and private organizations, traveled to foreign countries to assess American law enforcement initiatives abroad, and liaisoned with foreign law enforcement and officials to combat international drug movement. Also, another word I don't know if I could say. Anyways, yeah, we're done, YouTube, with all this censorship. I don't want to be censoring my words. It's so hard to run a channel with she unalived herself or, having to work around it. It's so stupid and annoying. All right, so before she began her career in public service, Ms. Foley worked as an associate at De Genova and Townsend in Washington, D.C., representing clients in tax, antitrust, securities fraud, and FEC violation cases. Ms. Foley received a Master's of Law from Georgetown University Law Center in 1996 after receiving her Juris Doctor from Loyola Law School. She received her Bachelor's of Arts from the University of Louisiana at Lafayette, where she studied English, philosophy, and French. All right, so there you have it. That is what I know about Leah Foley. So hopefully we find out some more about her. All right, let's move on to our first filing, which is a doozy. All right, so sorry it's a little blurry, having to deal with screenshots of people's screenshots, I guess. Um, all right, so defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. So, one theme that kind of has been thrown around a lot in this case is that the Commonwealth, they don't have a case, and part of their strategy is to drag things out and make her waste her time, energy, and money on things that she doesn't really need to. And this is going to be one of those examples, as well as I've got a couple others. But let's read through this. This is about 15 pages, and away we go. So, defendant Karen Reed's motion to recover expert related expenses. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to order that the travel costs and related expenses associated with defense expert Matthew Erickson's December 2024 trip to Massachusetts be paid for by the Commonwealth. So usually the defense pays for uh, their own experts and traveling and all of that. But so it's not a common request to ask for expenses recovered from a specific expert. So let's find out what's going on. Those costs, which include travel expenses, lodging, and other accommodations, and expert fees associated with the trip to the Canton Police Department, were incurred with or after the Commonwealth agreed to allow Mr. Erickson to visit the Canton Police Department so that he could perform an independent analysis of the CPD exact vision DVR system and any video footage it contained from January 29th, 2022 between 12 a.m. and 11:59 p.m. So the entire day's worth from that video system on the 29th when they recovered John's body and brought Karen's car into the Sally port, the backward Sally port. That's what this expert, Mr. Erickson, was going into to run extracts or whatever he needs to do, look at the reports and whatnot, and look at recover the data from that day. So that was his job, was to go back and get that Sallyport video, verify it, figure out why Sallyport video may have recorded backward or in reverse, things like that. So he was going there to investigate. When Mr. Erickson arrived at the Canton Police Department, all original DVD or DVR footage from the relevant date had been destroyed, at best due to improper preservation by the Commonwealth. So, at best, they just were really negligent in handling it. But at worst, they deleted it, is what this sentence implies. Because the Commonwealth failed to preserve the original video evidence, Mr. Erickson's trip to Massachusetts was futile. The costs associated with the travel to the Canton Police Department would not have been incurred but for the Commonwealth's representations that the evidence existed and that Erickson would be able to obtain the original copy of the video surveillance footage. Accordingly, in the interests of justice, this court should order that the Commonwealth, not Ms. Reed, pay the cost of having her expert travel out of state to obtain a copy of the video surveillance, which the Canton Police Department, an agent of the Commonwealth, failed to adequately preserve. What do you guys think about that? They they tell the defense, "Oh yeah, sure, sure. Send your expert. He can come look at the data. It's here. It definitely exists. Why wouldn't it exist? Come on up and check it out. Doo-doo-doo. Mr. Erickson arrives. No data. Nothing for him to look at. Nada. Trip wasted. All the police department had to do, or the Commonwealth, whoever arranged it, all they had to do was say, you know what? Oh, we messed up and we don't have that info anymore. That data just somehow magically erased after it was inverted and we recovered it after we couldn't find it before. And yeah, all sorts of problems with this video. It is an issue. So let's read this wonderful footnote right here. A motion to dismiss for extraordinary governmental misconduct based on the destruction of this and other exculpatory evidence is forthcoming. So remember back at the very beginning of trial and the team originally, this was like right at, it was leading up to trial. They were maybe like a week out or something. And they were about to file a motion to dismiss for extraordinary governmental misconduct, but they announced they were going to do it, and then at the last minute they decided not to for whatever reason. Maybe they figured it just wasn't worth it. They've already trials going. They just couldn't put their efforts into that anymore. So I don't know, but for whatever reason, they do have other things. It's not just the fact that this video was destroyed, reversed, mirrored, lost in the beginning, lost a second time now. There's issues here. And people blurry, the people popping in and out, blurriness, all sorts of issues, time missing, everything. So there's a lot of issues. So yeah, I would say that that's definitely grounds for a dismissal of these charges, but we know Bev, she'll just deny it. All right, factual background. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe: homicide in the second degree in violation of their Rule 265, count one, manslaughter while under the influence of alcohol in violation of 265, 13 and a half, count two, and then the third count is leaving the scene of personal injury and or somebody's loss of life. So that's another violation. So there's three separate charges: is the homicide, manslaughter while driving under the influence, and then leaving the scene. In preparation for trial, the defense requested access to the Canton Police Department DVR system and the drives that hold recordings from the CPD security camera systems so the defense expert, Mr. Erickson, could obtain video files in the native file format with all available metadata. So he wanted like the original file format, which is important if you're going to be analyzing what happened to that video. And because this guy is an expert at analyzing corrupted videos, uh, said video surveillance just happens to disappear right before he shows up, I guess. So again, they were looking for January 29th between the hours of 12 a.m. to 11:59 p.m. So basically the entire day. In order to ensure the accuracy and a complete download of all available data and metadata, the defense requested that their expert be allowed to make a mirror image of the DVR's system's drive. The video footage is of critical importance to the defense. The Commonwealth has provided the defense with CPD video footage on 3 occasions. Got another footnote here. I love their footnote. Notably, when Mr. Erickson arrived at the CPD to extract video from the DVR system, the security camera system was set to overwrite older video surveillance footage with new video surveillance footage after approximately 30 days. Notably, however, each of the 3 instances in which the Commonwealth procured CPD footage to the defense was far outside those 30 days. So somebody changed how it overwrites. Somebody changed that feature, that function within the system, because it wasn't like that before. They were receiving videos in the past that had way expired the 30-day limit. So the system was not overwriting anything prior to when he shows up. So it's very, very interesting, don't you think? On April 4th, 2024, shortly before the first trial in this matter, the Commonwealth produced footage from the CPD main driveway and CPD Sallyport front wall for the very first time. The Sallyport front wall footage provided by the Commonwealth omitted a 42-minute interval during which the SUV arrived at the CPD Sallyport garage. This missing footage could have been used to show the condition of the SUV's right taillight upon arrival at the Sallyport, and to date would be the only footage that serves this purpose. So the one camera where it would have shown her taillight just happens to not have been working or missing. They're missing the footage. It's not there. All right, so the condition of the rear tail light of the Lexus SUV at the time is it entered law enforcement's custody is perhaps one of the most critical and highly contested issues in this trial, very much so, because defense says the actors for the state, the police, law enforcement, did something to that tail light when they reversed the footage of the Sally port, and there's people back there where you think it's the wrong tail light and you're looking at a tail light that is intact, which happens to be the wrong tail light. So anyways, mid-trial on April 23rd, 2024, via a share link entitled Additional Sallyport Video Download Link, the Commonwealth produced additional footage from the CPD Sallyport back wall. At trial, Trooper Yuri Buchanan testified on direct examination that the footage of Ms. Reed's vehicle from this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV. So, accurate depiction, keywords there. And that, as seen in the video, no law enforcement officer approached the right rear tail light. Also, false. Very false. On cross-examination, however, it became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, despite neither the Commonwealth nor Trooper Buchanan having mentioned that it was reversed on direct examination. Uh, Adam Lally should have, when he introduced it, he should have introduced it, and questioned Trooper Buchanan. Is that the way, why you do see that four is backwards? Is that the way it was? Trying to elicit that. It should have been Adam Lally's responsibility to correct that, but they just tried to pull a fast one over us all, including the jury and everyone at home, and they think we're that stupid. Therefore, when the video appeared to show a person standing near the left rear taillight of the vehicle, in actuality, that person was in front, or in fact, standing near the right rear taillight, the taillight at issue. It remains unclear why the inverted video was withheld by the Commonwealth and produced to the defense in the middle of trial after the initial CPD surveillance footage was turned over by Commonwealth. So there was that original, which was uh, like black and blurry, and you could barely see what was happening. And then that was from the other angle. And then the angle that we're talking about, the reverse Sallyport one, that's the reversed angle. All right, so Most recently, post-trial on October 10, 2024, the Commonwealth again provided new video surveillance footage, this time from the CPD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side angles. This footage shows Brian Higgins arrive in the parking lot of the Canton Police Department at 1:26 a.m. This is new. This is new news. We did not know this at trial. Okay. There is this other footage of Brian Higgins. He said he was at home at like 1:40. Um, we'll get to that. So actually, let me pull that up right now. I pulled up a tweet from Aiden Carney today. He posted this. He says Karen Reed's defense team filed a motion today that included new video of Brian Higgins at the CPD, which was withheld from them at the first trial. The surveillance video shows Brian Higgins pacing around outside talking to someone on his phone at 1:34 a.m. He never mentioned speaking to anyone on the phone at the trial or at the state or federal grand juries. Had he done so, the defense could have filed a Rule 17 motion for his phone, which would be a lot stronger and less likely to be deemed a fishing expedition if they had video of him talking on the phone. Very true. He testified at trial that he was back home in West Roxbury at 1:40 and that it took 15 to 20 minutes to get home. This was all a lie. This was his excuse for being at the CPD in the first place. This is a Brady violation. So he's got a couple of video clips. They're very short. I'm just going to play real quick.
Where did you go from there?
I went back to West Roxbury.
And which vehicle that you described, which of those vehicles did you use to get from Canton PD to West Roxbury?
The Jeep Cherokee, Jeep Wrangler, sorry.
And if you know about what time was it that you got home to West Roxbury?
Could have been somewhere around 20 at 2. I'm not 100% positive.
So sometime between 1:30 and 2 a.m., is that roughly around?
Yes.
And where did you go from there?
I went back to West Roxbury.
1:30.
And which vehicle?
I'm sorry if that was quiet. I probably could have turned. Oh, I have it up. So yeah, between 1:30 and 2, he says he's at home.
How long did it take you to get home from Canton PD?
A little longer from after I moved the vehicles?
Correct.
I don't know. I mean, it could have been 15 minutes. It could have been 20 minutes.
How long did it take you to get home from Canton PD?
A little longer from after I moved the vehicles?
Correct.
Yeah, so okay, that was on repeat. So he says 15, 20
I don't
minutes.
know. I mean, it could have been 15 minutes. It could have been 20 minutes.
How long did it take you to get home?
Stop. Okay. Between 15 and 20 minutes it takes him to get home. He's seen on video footage saying 1:26 a.m. or at 1:26 a.m. He's arriving in the parking lot at 1:26. So he's just getting there at that time. So this footage shows him get there at 1:26, enter the Canton Police Department, and speaking to some unidentified individuals on the phone as he's leaving the department between 1:34:52 and 1:34:56 a.m. Significantly, this material and relevant evidence which establishes Brian Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the Canton Police Department shortly after John's death was withheld from the defense at the first trial. They did not know this. This is brand new bombshell evidence that there was some shady stuff afoot at the Circle K across the street from the Canton PD. No, the Canton PD. There was definitely something afoot. All right. So the video surveillance footage at issue was a major point of contention at trial in no small part because the Commonwealth was utterly unable to establish any chain of custody for the various clips of video produced to the defense from the CPD. The footage produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability, including the presence of the inverted video, so that's just one problem. And the large scale gap missing from the feed at the precise time at which Ms. Reed's Lexus should have been shown entering the CPD Sallyport garage, in spite of the fact that the Commonwealth claims the video surveillance feed is motion activated. So they're saying the reason that they don't have it is because it's motion activated. Well, that's the dumbest excuse because it would be motion coming in to the Sally port. So that kind of blows that theory out of the water. The fact that the Canton Police Department produced video surveillance with an inverted video and a gap in the footage at the critical moment, i.e., the precise time Ms. Reed's SUV arrived at the CPD garage, is not trivial. It goes to the heart of her defense. Great line. In response to the defense's request, Special Assistant District Attorney Hank Brennan agreed to allow defense access to this critical information and to make the arrangements necessary for Mr. Erickson to extract video from the DVR system. Accordingly, Mr. Erickson traveled from Phoenix, Arizona to Boston, Massachusetts on December 11th, 2024, and after making the arranged visit to the Canton Police Department, returned to Phoenix on December 12th. The work Mr. Erickson did in connection with this trip, as well as the flights, hotel, stay, Uber rides, and other accommodations associated with this travel to Massachusetts, cost Reed a total of $12,229.57. That's a lot for one very short trip that ended up in basically nothing because the Commonwealth bamboozled them once again. There's no other way to really describe it. They've been bamboozled once again by the Commonwealth. As planned, Mr. Erickson visited the CPD on the morning of December 12th to extract video from the DVR system. He arrived around 9 a.m. and was met by Colleen Crawford, a multimedia director and certified forensic video technician from the Norfolk District Attorney's Office, as well as 3 others. Ms. Crawford expressed surprise that Mr. Erickson was there to extract video from the DVR and relatedly, skepticism from the footage could still exist. Mr. Erickson subsequently asked whether anyone had access to the system to determine whether the relevant video footage was even present. They answered no, notably before Mr. Erickson made the trip to Massachusetts. Counsel for the defense team spoke directly with Ms. Crawford. So Ms. Crawford has some explaining to do. Who was made aware of the footage the parties had agreed would be extracted by the defense. So they were made aware by the defense that they had an expert coming. This particular woman spoke to someone from the defense and was like, okay, yeah, great, okay, we'll expect them, great, sure, okay. And they turn around and overwrite all their video. This is the Commonwealth. This is what we're dealing with. So after photographing the relevant equipment, Mr. Erickson began recording and then accessed the system. Initially, it appeared to him that there were only 30 days of video history and consequently that the relevant footage had not been preserved. That impression was confirmed when he navigated to the appropriate section of the DVR system where a search by day and time could be performed, and he ran a search for January 29th, 2022 between the hours of 12 a.m. and 11:59 p.m. That search returned 0 results. Yikes. Based on the size of the drives, the percent usage, and the remaining usable space, Mr. Erickson concluded that there was mathematically no possible way for the videos from January 29th to be present in the December extraction that he tried to do when he performed his search, unless they were manually saved and or properly preserved via standard forensic protocols, but they were not. Next, Mr. Erickson began the process of generating any activity logs for the date and of interest. This request ran for an abnormal amount of time without showing results. Huh, that's interesting. An abnormal amount of time showing no results. When asked whether the system had ever behaved this way and whether it could be expected to complete the request, the person on site who was most familiar with the system shrugged and said he didn't know. After investing approximately 10 minutes into this and similar actions with no results, Mr. Erickson determined that the relevant activity logs were also gone. Not only did they delete the data, they deleted the logs. Mr. Erickson, well, I mean, they're cops, so they know how to do it. They know how to cover up their crimes. So, Mr. Erickson asked the individuals whether they had done a forensic extraction of the drives to get the original data, to which they answered no. He asked how they preserved video when they needed to, and they responded that they simply manually saved the video from the DVR. Finally, he asked if they had a written protocol in January of 2022 or now for saving videos. They responded that they did not. The individuals refused to provide Mr. Erickson with a copy of the original video files that they pulled from the DVR system, stating that it had already been provided to the defense counsel. So basically, like they asked him, so what do you do with videos you want to save? Oh, well, we download them, we save them. Okay, great. So you saved those, obviously, because we have them. So can I get the original then? No, we already gave that to the defense. That, okay, awesome. Do you see how uncooperative they are? Like at every turn, they have to cut you down or shut it down because they don't want you getting the evidence, or the evidence doesn't exist, or it implicates them, whatever it might be. There's something that they're hiding. So when asked how they produced the footage to the court and or the defense, they looked confused. Mr. Erickson clarified by asking whether it was provided on a USB drive, a disk, or a share link. They could not tell him for sure, but eventually said it was probably a share link. The way CPD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The CPD's DVR system, like most, stores videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then that data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. So that's why the original is so important, I guess. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. Due to the Commonwealth's failure to preserve the original surveillance footage, Mr. Erickson was unable to extract video from the DVR system footage from January 29, 2022 to obtain relevant footage between 12 a.m. and 11:59 p.m., as previously arranged and agreed upon by all parties. Thus, the Commonwealth's failure to adequately preserve evidence has resulted in the destruction of one, a forensically sound image or hash verified copies of the video surveillance footage from CPD on January 29th, 2022, and 2, logs establishing the individuals who accessed, manipulated, copied, and or deleted the footage from January 29th, 2022 from the CPD DVR system. Long sentence. Gonna come back up for air. All right, so Mr. Erickson left only with the video and video recording of his work and photographs that he captured from the DVR menus, which demonstrate that the Canton Police Department and the Norfolk County District Attorney's Office failed to preserve all video surveillance footage and associated logs, both of which are material and relevant to the case. Here is the argument. Hold on one second. I need some water. All right, I'm back. So the Commonwealth had an obligation to preserve the original DVR surveillance footage from January 29th, 2022. So yeah, it's an obligation, not just like, you probably should save it. No, you're obligated to. You are required to preserve that because it's part of an investigation, especially when things are being questioned so scrupulously right, in that word, scrupulously, um, towards the law enforcement and prosecution. When we have questions about their integrity, things like the Sally Port video, which happened to be backwards and missing times, that's kind of important stuff. Kind of an obligation to be careful with that. So in Massachusetts, the Commonwealth has a duty to preserve exculpatory evidence for the defendant to inspect, examine, or perform tests on. State courts have repeatedly stressed the need for prosecutors to do their utmost to preserve and present exculpatory evidence which is available to the prosecution. So this is exculpatory, and that is another reason why they don't want it to come in. That's why they're fighting it so hard. But it's not their job to obscure or ob obfuscate. You know the word. I don't know why I can't say where I'm hurting today. I'm also on pain meds, so apologies. But it's not the job of the prosecution to hide the truth or to keep the truth from coming out, which is exactly what they seem to be hell-bent on in this case, rather than, getting to justice, the truth. They've just been protecting the McAlberts and trying to protect their own asses, is basically how I see it. Evidence is considered exculpatory if it merely tends to diminish a defendant's culpability. Any evidence which tends to impeach the credibility of a key prosecution witness, such as evidence showing that footage of the defendant's vehicle, the alleged homicide weapon, has been tampered with or altered, is clearly exculpatory. For the loss of the original DVR surveillance footage, Ms. Reed is entitled, at a minimum, to recovery of expert-related expenses. They're not messing around this time. When potentially exculpatory evidence is lost or destroyed, as here, a balancing test is employed to determine the appropriateness and extent of remedial action, the courts must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Here, the balancing test indicates that the Commonwealth is culpable for the loss of the original footage. The footage was material evidence and its loss prejudiced Ms. Reed, definitely. Because not just its loss, but it's the misrepresentation of the video as well did not help Ms. Reed, because originally we all thought we were looking at the opposite taillight. The Commonwealth is culpable for the loss of the original DVR footage. Critically, for purposes of this balancing test, the Commonwealth is culpable for the conduct of its agents, and culpable conduct includes actions ranging from intentional to negligent and inadvertent. So even if you just did it accidentally, negligently, or intentionally, they are still culpable. So there needs to be a remedy for the atrocity that they tried to hand over as the evidence of the Sally Port. So therefore, the failure of Canton Police Department to preserve the footage, whether intentional, reckless, negligent, or inadvertent, is attributable to the Commonwealth. In this other case, Harvard, the prosecutor's obligations for proper handling of exculpatory evidence extend to material in the possession or control of members of the prosecutor's staff and others who have participated in the investigation or evaluation of the case and who either regularly report or with in reference to the particular case have reported to his office. So anyone. All right. Here, sorry. Oh, I missed a footnote. Where was that footnote? I don't see it. Oh, I didn't miss it. Okay. Here, the Canton Police Department was in possession of the footage, knew that it was potentially exculpatory before it was lost, and failed to preserve it. Here goes the footnote. The relevant footage from January 29th. Ms. Reed was arrested just 3 days later on February 1st and arraigned on February 2nd by Assistant District Attorney Adam Lawley. The Commonwealth was thus on notice about the potential use of the footage with ample time to properly preserve it, even if footage was normally set to delete after 30 days. They knew that this was a crime. They had her arrested within 3 days, or they were looking at it as a crime. I mean, it is a crime, but they have it all backwards. But, anyways. So, relevant members of the Norfolk County District Attorney's Office also failed to take steps to have the data preserved. Upholding lower court decision that the Commonwealth was responsible for the inadvertent loss of the evidence and was culpable for its failure to preserve exculpatory evidence, given the failure of the Assistant Attorney General to be sure that the file was preserved, and the negligence on the part of the allegedly defrauded company, which was working with the prosecution in misplacing the file. All right, next point is the original DVR footage was material. Evidence is material if, in considering the entire record, it creates a reasonable doubt as to the defendant's guilt that would not otherwise exist. Reasoning that the Commonwealth's failure to preserve the original letter prejudiced the defendant because the original was necessary to know whether the signature was forged and whether it was not, and because if it was not, the Commonwealth's principal witness may be impeached and the defendant's case substantially advanced. So that's regarding another case. If they have the original, then they can verify if the signature was accurate and if in legit original. If not, then they can impeach someone. So that's how important having the original piece of information is. So that was a really good example or analogy that they showed us there. So here the relevant video evidence speaks to the state of Ms. Reed's vehicle immediately after John O'Keefe's death and as well as the handling of the vehicle by CPD, both of which are key issues in this case. In some cases, it is important for the Commonwealth to maintain and preserve the original piece of evidence rather than a copy. Finding that loss of original letter prejudiced defendant because defense expert could not determine authorship based on a photocopy where authorship was relevant to a fraud claim. So that's why it is so important. Finding that loss of original paper bag with handwriting found at homicide scene did not prejudice defendant because handwriting expert stated that photograph of the bag was adequate for his analysis and testimony was based on the photograph, which defendant had access to. This is one such case. First, the original DVR data and footage was necessary for proper analysis of the authenticity and integrity of the video, both of which were actually at issue here. So, the very things that you need to verify with this video, you can't. So that is especially concerning in this case where there is substantial evidence suggesting that the videos have, in fact, been altered despite claims to the contrary by the Commonwealth and its agents. And we have a footnote here that says, specifically, the surveillance footage produced by CPD included an inverted video and footage with significant gaps, including gaps at the precise time Ms. Reed's Lexus entered the CPD Sallyport garage. I knew this was going to come up in a filing at some point. This had to be an issue because they never addressed it at trial. They should have been a mistrial, or, she should have thrown out the charges right then and there because there's some shady stuff going on. But obviously, this is Bev, so she's in on it, and she let the trial go. All right, second, because of the methods used by CPD to access a playable format of the surveillance footage, the videos ultimately produced by the Commonwealth are of lesser quality than the original footage. For these reasons, the fact that the videos are available in some form is not sufficient. The videos in their original format were material and should have been preserved. Next point, the loss of the original DVR footage prejudices Ms. Reed. As detailed above, there is significant evidence that the DVR footage provided to defense and shown at trial was altered. The fact that the original DVR footage is now permanently unavailable hinders Ms. Reed's ability to demonstrate the differences between the original footage and the footage provided to defense and shown at trial. Differences suggesting the footage was tampered with or otherwise altered, and deprives her of critical evidence about how those differences came to be. I surely hope that this goes well beyond just, uh, throwing it out or, uh, I hope something comes of it in regards to Adam Lally might be disbarred or Judge Bev even because of all the misconduct that was happening. Like, I hope it goes, there's something so much bigger at play. The fact that this got deleted, even though they definitely should have known that it should have been preserved. Um, it just goes to show guilt on my part, on their part, I think. In my opinion, it shows that they have a consciousness of guilt. All right, so unbelievably, the fact that the original DVR footage is now permanently unavailable hinders her ability to demonstrate the differences between the original and the footage that was provided, and deprives her of critical evidence about how the differences came to be. So having that um, original file to look at the original data that doesn't always transfer over when you copy something, it would have really helped to show how the video got flipped. If in fact that might have been a manual thing, perhaps. All right, so at this one, defendant was not prejudiced by loss of original bloody fingerprint, where both experts testified that inconsistencies between the original and photograph could be identified and fully explained without the original by the different conditions under which each print was obtained and which no evidence suggested the blood contained in the original could be used for DNA testing. Ultimately, the loss of this evidence in its original format, which resulted directly from the actions and inactions of the Commonwealth and its agents, hinders Ms. Reed's ability to put on an adequate defense. The loss of the DVR footage in combination with the Commonwealth's misrepresentations further prejudices Ms. Reed by burdening her with a significant and unnecessary financial burden. So here's where it comes to all of this stuff is financially, it falls on Karen financially. Bringing in Dr. Marie Russell twice because Hank Brennan wanted to grill her for an entire day. Um, she had to pay for that. That comes out of Karen's pockets and the taxpayers' pockets for Brennan and running that court, all the staff members and everybody there. Excuse me. All right, so the loss of the DVR footage in combination with the Commonwealth's misrepresentations further prejudices Ms. Reed by burdening her with a significant and unnecessary financial expense. The Commonwealth, by agreeing to and arranging the CPD visit, led Ms. Reed and her team to believe that the relevant footage existed and that the defense's forensic expert would be able to forensically extract the relevant footage if he flew to Massachusetts to visit CPD. Because of the Commonwealth's representations, defense expert Mr. Erickson did fly from Arizona to Massachusetts, stayed overnight at a hotel, and traveled to Canton PD for the agreed upon imaging. Yet, he was never able to perform the imaging as the Commonwealth had failed to preserve the information. The Commonwealth failed to take any steps to determine whether the footage still existed before prompting the defense to send its expert to Massachusetts, despite an apparent understanding by CPD technicians that such footage did not exist. So if they knew that their machines or their system was on a 30-day rewrite, then they would have absolutely known that they wouldn't have had the footage there in their system. So why the heck didn't they tell them ahead of time before their guy flew out? For the services rendered on December 12, 2024, and associated travel costs, Ms. Reed paid defense expert Mr. Erickson, employer USA Forensic LLC, a total of $12,229.57. This expense is significant and draws on the financial resources needed by Ms. Reed to defend herself at trial in this matter. They should absolutely be on the line for this, the Commonwealth. So the appropriate remedy for the loss of the evidence, at a minimum, recovery of these expert-related expenses from the Commonwealth. Given the materiality of the lost evidence, the prejudice to Ms. Reed, and the culpability of the Commonwealth, Ms. Reed is entitled to a remedy. There is no particular remedy for the loss of evidence. Instead, our courts have fashioned or upheld various judicial remedies, from allowing the defendant to bring to the jury's attention the Commonwealth's negligent handling of the evidence to dismissal of the indictment, which should happen here. Why we're still going, the corrupt people in Massachusetts are the only ones that still know. These decisions are within the sound discretion of the trial judge and are reviewed for abuse of discretion. Because the travel expenses and expert fees associated with this trip were the direct results of the Commonwealth's, I'm gonna highlight that. They were the direct result of the Commonwealth's representations to the defense. And because the Commonwealth's failure to fulfill its obligations of preserving the video made the defense expert's trip to Massachusetts futile, Ms. Reed is entitled, at a minimum, to recover these costs from the Commonwealth. Allowing Ms. Reed to recover these expert-related expenses from the Commonwealth is in the interest of justice. Ms. Reed is not indigent and therefore would typically be responsible for her own expert costs and fees, providing for coverage of an indigent defendant's witness expenses by the Commonwealth, but not for coverage of such expenses for non-indigent defendants. However, the Commonwealth's actions have caused significant unnecessary travel expenses for defense expert Mr. Erickson and thus for Ms. Reed. Accordingly, Ms. Reed now seeks to recover these travel costs from the Commonwealth. To order the Commonwealth to pay these fees is within the court's discretion and is in the interests of justice. The interests of justice require the Commonwealth to bear the cost of having Ms. Reed's expert travel out of state to the Canton Police Department to copy files which the Commonwealth knew had already been deleted. To force Ms. Reed to pay the expenses out of pocket when she is already prejudiced by the loss of evidence itself would be a complete miscarriage of justice. Defense expert Mr. Erickson traveled to Massachusetts as part of an arrangement made between defense and the Commonwealth, in which the Commonwealth represented to the defense that Mr. Erickson would visit CPD. So the Commonwealth represented to the defense that Mr. Erickson could visit CPD and extract the relevant footage. At the time the Commonwealth made that representation, it knew or had reason to know via its agents, who were responsible for properly preserving the footage but did not, and via Assistant District Attorney Lawley and Special Assistant District Attorney Brennan, who did not take the actions necessary to ensure the evidence was preserved by those agents. So not only are they blaming Ms. Crawford for misrepresenting that the files were there and they could come and get do their extractions and all that relevant stuff. But they're also throwing Adam Lawley and Hank Brennan under the bus, saying, and you guys, it was your job to preserve that. And it is. I mean, they're not saying anything that is not correct here. It would have been their job to let the state, the, the police department know not to overwrite those. I can't believe police departments would have an overwrite feature. Like, really? When just about anyone at any time, anywhere, a crime could occur, something could occur, and someone could come back there and be like, yeah, this happened, but it was a month ago, and sorry, you're just out of luck because now we don't have the evidence. That's just so stupid. The Commonwealth induced the defense expert to fly to Massachusetts anyway, wasting Mr. Erickson's and the defense's time and causing the defense great expense. Ms. Reed should not be forced to shoulder this unnecessary financial burden. She shouldn't. The travel expenses and other costs associated with Mr. Erickson's December 2024 trip to Massachusetts were incurred as a direct result of the Commonwealth's failure to meet its obligation of properly preserving material evidence. This misrepresentation came at a significant expense to Ms. Reed, who paid in total $12,229.57 for these expert services and the related travel. Because the Commonwealth arranged for the defense expert travel to Massachusetts to inspect evidence that the Commonwealth had not properly preserved, it is in the interests of justice that Ms. Reed be allowed to recover these related costs. I agree. I hope they reimburse her for that. For the above reasons, Ms. Reed respectfully requests that this honorable court grant her motion to recover expert-related expenses related to the defense expert Matthew Erickson and his trip to Massachusetts in December. So that is the filing from the defense, and we also have the affidavit from Mr. Erickson himself. All right. I, Matthew Erickson, do hereby depose and state the following is true to the best of my knowledge and belief. I am a computer IT and mobile device forensic analyst at USA Forensic LLC. I was retained as an expert witness by defendant Karen Reed in the above captioned matter for the purpose of analyzing the current DVR configuration and obtaining forensic video surveillance evidence from the CPD. On December 11th, 2024, I traveled from Phoenix, Arizona to Boston, Massachusetts by plane to render expert witness services in the above captioned matter. I stayed in a hotel for one night and returned to Phoenix by plane on December 12th, 2024. The purpose of my trip was to allow me to extract surveillance video from the Canton Police Department's Exact Vision DVR system in a forensically sound manner which aligns with the methods accepted and commonly used in the digital forensic community, as well as review any video footage preserved within the system from January 29th, 2022, between 12 a.m. and 11:59 p.m. I visited the Canton Police Department on December 12th, 2024 to do so. All right, we got all that information in that one paragraph that was very um, descriptive. I arrived at CPD on the morning of December 12th, 2024 to begin my review of the DVR system around 9 a.m. and was met by Colleen Crawford, who I was informed is a multimedia director and certified forensic video technician from the Norfolk District Attorney's Office, as well as three other individuals. Ms. Crawford expressed surprise that I was there to do this work, relatedly, skepticism that the footage would still exist. I asked whether anyone had accessed the system to determine whether the relevant video footage was present. They answered no. Notably, before I made this trip to Massachusetts, the defense team spoke with Ms. Crawford and she was made aware of the footage the parties had agreed would be extracted by the defense, specifically relating to the accepted date and time parameters that would be used for these processes. After photographing the relevant DVR equipment, I began recording audio and video and then access the system initially. Initially, it appeared that there were only 30 days of video history and consequently that the relevant footage had not been preserved. That impression was confirmed when I navigated to the appropriate section of the DVR system, where a search by day and time could be performed and ran a search for January 29th, 2022, 12 a.m. to 11:59 p.m. That search returned 0 results based on the size of the drives, the percentage use, and the remaining usable drive space. I concluded that there was mathematically no possible way for the videos from January 29th, 2022 to be present in December of 2024 when I performed this search unless they were manually saved and properly preserved via standard forensic protocols. So there's an unless, but we got to remember this is Canton PD and they use leaf blowers and solo cups for their crime scenes, so there probably isn't a forensic protocol standard that they use. I'm just guessing. All right, next, I began the process of generating any activity logs for the dates of interest. This request ran for an abnormal amount of time. There that is again, the abnormal amount of time, which I just think is fascinating. Like, why did it take so long for it to look for the date again in the activity log? There were no results. When asked whether the system had ever behaved this way and whether it could be expected to complete the request, the person on site who was most familiar with the system shrugged and said he didn't know. After investing approximately 10 minutes into this and similar actions with no results, I determined that the relevant activity log was also gone. While there, I asked the individuals whether they had done a forensic extraction of the drives to get the original data, to which they answered no. I asked how they preserved video when they needed to, and they responded that they simply manually save the video from the DVR. Finally, I asked if they had a written protocol in January 2022 or now for saving video. The response was no, they did not. The individuals refused to provide me with a copy of the original video files that they originally pulled from the DVR system, stating that the information had already been provided to the defense. What are they hiding? When asked how they produced the footage to the court and or the defense, they seemed confused. I clarified by asking whether it was provided on a USB drive, disk, or share link. They could not tell me for sure, but eventually said it was probably a share link. I explained that getting a copy of the video files directly from them would help us ensure that they were working with the same hash verified data that was disclosed to the defense. They continued to advise that I get these files from the defense and declined to provide me with any of the original files. Huh. Huh. They really think we're that stupid that we're not onto them. The way CPD technicians extracted the video data from their own DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The CPD DVR system, like most, stores videos in a proprietary format. CPD uses the DVR interface to pick and choose what videos to save, and then that data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. Due to the Commonwealth's failure to preserve the original surveillance footage, I was unable to extract the DVR system from January 29th to obtain relevant footage between those hours as previously arranged and agreed upon by all parties. The plane the plane fare in total cost $2,202.96. The one night hotel stay in total cost $233.77. Uber trips to and from the airport, hotels, and Canton Police Department in total cost $314.72. Other expenses, snacks and beverage at each airport, and Wi-Fi on the December 11th flight to Massachusetts totaled $103.12. The fee associated with the 10-hour December 11th travel day was $375 per hour, or $3,750 in total. The fee associated with the 15 hours of work performed at the Canton PD on December 12th and in Phoenix, both before and after the trip, was $375 per hour, so $5,625 in total. In sum, the total expenses for travel, fees, and related costs associated with my December trip to Massachusetts totaling $12,229.57. Signed and sworn to under the pains and penalties of perjury. That was signed yesterday by Matthew Erickson. So there you have it. That is the motion itself and the affidavit from Matthew. However, somebody had posted this. I think it was Olivia. It was either Olivia or Lana. I always get them confused because they're both like such great resources, and I use them a lot for my resources. So I hope I'm Lana Del Turtle and Olivia are the ones I'm talking about on X. They have some great informational posts. Well, anyways, one of them, I want to say it was Olivia, posted this regarding some other instances where the Commonwealth might have been dragging out Karen's time, resources, money, energy, all that good stuff. So here is an example. This in purple here. It says, uh, this is an affidavit of David Unetti in support of defendant's renewed motion to compel discovery. So at this point, they were trying to get, I'm not sure what they were trying to get. Hold on. Let's just read. All right. So on May 27th, 2022, which was an agreed upon date with the prosecution, the defense sent Ms. Carrie Alvino, an expert accident reconstructionist, to travel to inspect Ms. Reed's Lexus in police custody. Oh, yeah. So this was like early on, May 2022. They sent an expert, a reconstructionist, to go see Karen's car. But things were a little odd. So the defense was not told in advance that the Lexus would be stripped of any evidentiary value, but that is what occurred. So they get there and all the data from Karen's car is gone. Sound familiar? Because they just pulled this crap just now again with the Sallyport video. Pieces of taillight, the taillight housing, the event data recorder, and the Lexus infotainment system all had been removed from the vehicle before Ms. Alvino was allowed to inspect it. She was denied access to the evidence missing from the vehicle. The cost of Ms. Alvino's fruitless visit to inspect the vehicle was borne by Ms. Reed. They should get expenses back from that too. And this is another instance here. Um, this is for Rule 17 motions for cell records. I think this might be for Jennifer McCabe and Brian Albert's phones. So Ms. Reed expended significant funds subpoenaing witnesses in preparation for a hearing. This is when Bev just decided there wasn't going to be an evidentiary hearing, and she didn't give any reason why, even though it had already been scheduled. So this is yet another way in which Bev has screwed Karen over out of money and resources. So they had witnesses lined up in preparation for the hearing, including Brian Albert, Jennifer McCabe, and the Commonwealth's computer forensic expert, Trooper Garino. So Brian Albert, Jen McCabe, and Trooper Garino were lined up to testify in an evidentiary hearing regarding Rule 17 motion for their phones. And Bev just canceled. And they were flying in an out-of-state expert to testify regarding his findings on Jennifer McCabe's cell phone, so that must be Rick Green, and preparing for the examination of witnesses at the evidentiary hearing that was stipulated by the parties and placed on calendar by the court. So the calendar had it on their docket that this hearing was supposed to take place. However, on May 22nd, 2023, 3 days before the scheduled hearing, without any advance notice to Ms. Reed or her counsel, the Commonwealth, Brian Albert, and Jennifer McCabe, clearly acting in concert, filed a flurry of motions requesting inter alia all the evidentiary hearing that the evidentiary hearing be set for May 25th suddenly be canceled. So 3 days before this evidentiary hearing on the 25th, I remember this pretrial hearing too. All these people, the attorneys for Brian Albert, I think Higgins' attorney even came forward, Jen McCabe came forward, and they did not want um, this hearing to go forth. They were like fighting like hell to not have to turn over their phones. So that's another example. That's two other examples right there where they should request money back. They should make Judge Bev pay for it. They should make Judge Bev pay for it because she didn't give a reason. The court should pay for that. Judge Bev, her out of her own pocket. Is what I think. But anyways, that'll probably never happen. Anyways, thank you guys so much for watching, for reading along. Don't forget to look at the link because you can download and go back whenever you want. And thank you guys so much for reading along and for your valued opinions in the comments below. Let me know what you think. about this? Is it going to go anywhere? Do you think she's going to get the reimbursement? I mean, it's pretty well written and um but I always say their stuff is well written and they have a good case, but then Judge Bev does Judge Bev. So she's probably going to deny it as usual, but let's just see. I have a little tiny bit of faith that she might just be like, okay, I'll throw this bone to them so that I can destroy everything else in the wake of her trial. So I don't know. She might. She just might give it to them, but who knows? Let me know what you think in the comments below, and I will see you guys in the next one. Take care. Bye now.